Joining us now is healthcare expert Seth Denson.
Healthcare expert Seth Denson is here to break it all down for us.
Welcome back, everybody, to another edition of Doctor Will See You Now. I'm Seth Denson. We are obviously bringing this to you thanks to GDP advisors. All throughout this coronavirus pandemic, we've been bringing you information that we think is extremely important for everybody. We're answering your questions, and we've actually had specific experts as our guests talking through an array of issues that we're all facing. And so if you've missed any of our past episodes, I want to encourage you, you can go to our YouTube or Facebook pages. You can go to our blog at gdpadvisors.com. And you can find past episodes where our guest experts are answering questions and addressing those concerns that might be out there. Today's topic is actually one that was posed by a number of our clients over the past couple of weeks. And it's regarding, as we start to reopen our country, what do we do if we're an employer from a compliance perspective? And if we're an employee, what rights do we have? And so whenever we have specific compliance questions, we turn to our friend Mark Rambo. If you're a client of GDP Advisors, probably you've interacted with Mark. If you haven't, you certainly have gotten information that came from Mark, as Mark serves as our Director of Compliance at GDP. We're thrilled to have him as our guest today. Mark is one of the co-founders and kind of the head of compliance for HR Workplace Services, which services thousands of employers across the country, many of which we represent. And so, Mark, thanks for joining us today and being part of this.
Happy to be here. Thank you. Thank you.
So let's start off with just, you're in Arizona, right?
We are.
How's life in Arizona these days? Have we opened up?
We're getting there. We're slowly opening up, but I think I think we're a little ahead of the curve compared to other places, but I think so far it's been going well.
Excellent. As always, we'll be taking your questions. So if you have specific questions for Mark, specific to opening your business, what rights do you have? What things should you be aware of? If you're an employee and you're being told you need to go back to work and you've got questions about what rights you may have, Mark is here to answer those. If you got questions about, your benefits and your health insurance policies and COBRA and all those other things, Mark has been gracious enough to give us his time. We want to make sure we answer your questions. Mark, I would like to just start off with one specifically to maybe what's going on federally. All right, we've got the CARES Act, we've got all this legislation that seems to pour out every day. It also seems to be that we pass a law only to find a way to interpret it tomorrow. What are you seeing from the perspective of the federal government's response to this? Are there anything glaringly new that employers should be aware of as they start to consider opening their doors?
Sure. There's a handful of things, as you said. The legislative process is can be a little wonky at times. We get legislation passed, but we don't necessarily know what it means, and so we wait for the guidance. And as we sit here today, the Department of Labor, going back to the FFCRA, has released guidance now 5 times. Right, they continue to update. We're just now starting to see the IRS get in the game a little bit as it relates to, as we've seen in the last couple of days with regards to Section 125 issues, joint guidance with the Department of Labor, IRS, on some delayed, what they're now calling the outbreak period, which is some delayed period as it relates to COBRA, some other ERISA type benefits. We are, in fact, today waiting for the SBA to finally issue some additional guidance on loan forgiveness under the PPP. So you're right, Seth. Every day there's, whether it's a revision, whether it's an update, or whether it's something new, but you definitely have to keep your head on a swivel. There's no doubt.
So there's a lot of rules and regulations at play here, right? You've got everything from workers' comp legislation to general liability, and I'm talking obviously from insurance terms, but there's typically laws that govern this. One of the questions that we're getting a lot from employers is, as I reopen my doors and ask my employees to come back, what general liability do I have if they ultimately say, I got coronavirus while coming back to work?
Sure. So as a general rule, we're not, as an employer, we're not required to allow employees to work from home. Obviously during this pandemic, we've made a lot of concessions. We've sent people home. I think a lot of organizations, Twitter is a great example, that has determined that that's actually not a bad strategy and one that they will continue on a go-forward basis. But if you're opening up, if you're a manufacturing facility, if you are non-essential, last week here in Arizona, we were able to open up salons and barbershops and things of that nature. So we do have a duty. Certainly the CDC has issued guidance as to how we should sanitize our workplaces, how we should maintain social distancing. Some of the things that we should be doing, whether it's mask wearing, whatever the case may be. An employee who simply is scared, that's generally not a qualifying reason to be at home. However, as an employer, we need to determine, are they in a vulnerable category? Or are they, perhaps they will be eligible for some of the leaves under the FFCRA. Perhaps there's some ADA issues. From an employer, we also still have OSHA's, this catch-all that you're very familiar with as well, which is the general duty clause, right? The general duty clause it's very broad. It simply says that as an employer, I have a general duty to provide an environment that's free of hazard and free of injury. So there's going to be some there's going to be some work on the part of employers now going forward to show that, we're doing everything we can to create an environment that's safe, not only for staff, but also for our customers and clients that we're hoping to get back as we start down this road of economic recovery.
Are there specific states that are kind of, maybe we'll call it, pardon the pun, trumping the federal law and saying, we're going to set a different parameter of guidelines that, this is how you're going to do it, this is what is going to be required, and you could be held either civilly or criminally liable for
and that's a great point. I think we are seeing examples of that. I think we saw it earlier this week where in Wisconsin, the state Supreme Court came down and nullified the stay-at-home order by the governor. The cities, if you will, Madison, for example, almost immediately reenacted some of their own local issues, local restrictions, mask wearing, social distancing, things of that nature. So will we see more of that as at the state level, the governors start to loosen things up? Will we see some more tightening at more of a local level? Perhaps. But, if you live in a metro area like I do, to move from one city to the next is pretty easy. So, depending on what's going on in the various localities. But yes, I think that, certainly in California, we're seeing that where there's this mix from northern to southern. So there is. I mean, certainly states are going to be doing different things. Clearly in the Northeast, where there's they're still having some challenges. You would certainly think of them doing things differently than perhaps where you're at or where I'm at here in Arizona. So, it's going to be interesting depending on where you have employees, especially if you're a multi-state employer. Where are my specific staff? I need to be in tune with what's going on.
So if you're just joining us, our guest today is Mark Rambo. He is our Director of Compliance here at GDP Advisors, also is one of the co-founders of HR Workplace Services. who helps oversee compliance and guidance for employers across the country. Mark, as an employer who's looking at reopening, are there certain things that I need to be looking at, or any employer should be looking at, as to who to maybe bring back to work first? And in so doing, are there any fears of maybe discriminatory rules that might be out there that I could break if I've got an employee that doesn't want to necessarily maybe comply with the ones I want to bring back first?
Yeah. And that's an interesting scenario, and it's certainly one that I think employers need to be mindful of. That as we start to restaff, this whole concept in the beginning was, who do I consider essential and who really is non-essential? Certainly, employers have used variations of layoffs and furloughs for a number of different reasons. Some to their own advantage. We'll leave it at that. But the idea of, as I start to ramp back up again, I need to look at identifying, who's really essential to help me kind of get the ground running, and where are those folks. Assuming that I'm going to be able to get them back, but being able to identify on a non-discriminatory basis. In other words, this really isn't a time for us to play favorites, if you will. It's really evaluating, going back, if you will, to the skills and experience that I have in my staff, who are perhaps my essential workers as it relates to particular launching, if you will, getting the business back open, or getting it back up and running. And then as I slowly start to go through this process, then I can start to hopefully bring back the rest of my staff. But I think for now, yes, clearly, I think if we look at it purely from a perspective of really focusing on those folks who are going to be able to help me kind of get the ball rolling. They've got those skills and requisite experience that I need in order to do this. Then the folks that are really more on the non-essential side, we can start bringing them back on once we get more full speed ahead.
So you bring up furlough, and this is a term that you and I've known for some time, but many haven't. True. Could you maybe define for our audience the difference between letting someone go and furloughing them, and then perhaps maybe what the rules are different from one to the other as they pertain to maybe benefits and things like that? Sure.
So as a general rule, a furlough is a term that we've really only heard when we've had government shutdowns. You see where we can't get a budget passed, and so governments will furlough, if you will, staff until such time as the budget comes in and we can start paying employees again. So a furlough really is it's an unpaid leave. It's a mandated leave. We're going to mandate that you not be at work because we can't pay you. A layoff really is a termination. And so we terminate, albeit we may have the intention of rehiring once economic conditions change. But a layoff really is a termination by definition. So when I terminate, obviously the benefits typically are not continued because you're no longer an employee. And so we typically look to COBRA first in that regard. Furloughs get a little more tricky because now technically you're still an employee. You are on leave just like you would be on any other unpaid leave that the employer provides. The challenge is that when these furloughs exceed 30 days, maybe go into 60 days, potentially looking at 90 days, then you start getting into some benefit challenges, which can differ based on whether you're a small group or a large group. Large group meaning an ALE subject to ACA rules versus a small group, which can really look to COBRA for the reduction in hours. So it does become a little bit more challenging But with a furlough, typically we still have benefit considerations that we wouldn't have in a layoff.
Do you think that in this new era where furlough is somewhat of a commonality, that beyond maybe just the government's role, that employers should take this opportunity to review their plan documents or maybe even their employee handbook to make sure that it addresses specifically how benefits would be provided in a furlough situation?
Sure. So there's going to be there's going to be a number of policies that are going to change as a result of this. I think you're going to see a rewrite of whether it's benefits and benefit continuation. You're going to see drilling down on leave policies. Bridging, if you will, of seniority. There's a number of policies that I think that are going to be impacted in this regard. In terms of furloughs versus layoffs, with furloughs and benefits, certainly there's going to be a need to update our plan documents, update our policies. Certainly with the guidance that's being issued now by the Department of Labor, by the IRS, as it relates to Section 125, qualifying events that are now changing. We've got FSA changes. The CARES Act gave us some changes with regards to HRAs, FSAs, and HSAs on over-the-counter medications. So the simple answer is yes. There's a lot of amendments that are going to need to be done to not only our policies, but also our plan documents.
Are you hearing anything about the federal government taking up sick pay leave, right? So I know that in the expansion of FMLA, right, this was an unprecedented rule that was set forth that employers had to, and specifically small employers, which usually were exempt from FMLA, had to provide 2 weeks. And then extended FMLA beyond that. Is this something? Are you hearing anything about that becoming permanent, and that may we see a federal law surrounding sick pay leave?
I think we're certainly closer to it today than we were prior pandemic. There was currently legislation sitting in the House that provided for a paid sick leave, that would provide for up to 40, if not, there were some amendments being proposed that would increase that to 80, but certainly 40 hours of paid sick leave is a general rule. That has stalled. It did not make its way to the vote or to the floor for a vote. Do I think that somewhere this is going to get picked up? I think you and I both know that once something is put into place, it's much easier for Congress to continue it than it is to try to get it passed from scratch. We've seen that with, we just saw it recently with the extension of 10 years for the PCORI fees. We've seen that with the continued expansion of perhaps the Patriot Act. So I think, once something's in place, it's very difficult to take it away. And so I think we're going to see some of that with some of the provisions that have been provided, whether it's through CARES, whether it's through FFCRA, HEROES Act, the one that we're now in debate with in Congress. I think there may be elements of that we'll see a little bit. So yes, I think once these things are in play, I think they're much harder to sunset, and I think we'll see some continuation of these things once we get past this.
So let's kind of talk about an employer that's wanting to reopen their doors, and they reach out to their employees and say, okay, it's time. We're following proper protocol. We're going to provide PPE or whatever that might look like, and they have an employee that says, nope, I'm not coming back. What are there rules around that? What should an employer do in that situation?
Sure. Well, I think one of the chances, and I think that anyone who has been watching this, it certainly has made the news rounds, is the fact that because of the robust unemployment benefits that have been provided by the CARES Act, we've created for ourselves, to some extent, a disincentive for people to come back to work. And the federal assistance runs through the end of July. The new stimulus bill that is being discussed in the House would extend those unemployment benefits through the end of January of next year. So, which would essentially give folks almost a year of benefit in that regard. So, there are going to be some folks who question, are we just continuing this disincentive? So there's going to be some changes. States have now waived requirements in many ways for employees having to search for new employment opportunities. There's been the waiver of the wait week. We've already extended, as I've said, we've extended state benefits from 26 to 39 weeks. So I think that's a big challenge that as employers we have to getting people back to work. In addition to that, you are going to have a segment of employee that simply is scared. Just regardless of the efforts on the part of the employer, they will simply just refuse. We're still going to have, we still have daycare issues. We're still going to have, we're coming up into the summer. If the FFCRA, if you read the language, and as part of the FAQs that have been issued by the DOL, that daycare and childcare will extend to day camps and summer camps. And so if those particular things are not available, then we may try to see an extension of things. I've had a number of employers who've talked to me about some of their female employees who are currently taking expanded FMLA to care for a child, but they also happen to be pregnant and they will be due in the fall. And so, there's a number of challenges that as an employer we have to get our folks back to work. The DOL, a number of states have said if work is available and you were recalled and there's full wages available, that simply quitting your job, if you will, without any good cause to obtain additional benefits could be seen as fraud on the unemployment system. But then you also have states, for example, California, who has said that it's possible that benefits may continue if there's probable cause or if there's good cause. And so we need to understand what that good cause means. So again, there's a lot of things that are coming into play to get people back into the mode of working, providing service, providing products, manufacturing, all of our sectors. But I think it's going to be a process. It's certainly not going to happen overnight.
So everything you've just described screams ambiguity, right? And that's the legislative process at best, right? Yeah. So given that, right, what do you tell an employer who says, man, I think I'm doing the right thing, but I'm not sure. Can I be held liable? What can an employer do to protect themselves as best as possible, right? You never know what might make its way through the court system, but what can an employer do to do their best to protect themselves through the vague aspects of all of this?
Sure. Well, I think that there may be opportunity, obviously, for us to hire new staff. I mean, there's nothing that says that because I have an employee who doesn't want to come back, that I can't replace that employee. Now, if they're on a particular leave or a protected leave, then so be it. But I think there's numerous instances, and certainly we've been informed of them, where employees perhaps are taking advantage of the particular systems that are there. And there's excuse after excuse after excuse, or whatever the case may be. So there's nothing that says employers can't certainly forge ahead, if you will. The best that we can do is to create a good environment, is to create a safe environment. Publish, to staff, put in your policies what cleaning protocols are going to look like. We're going to, if there's any masking that's going to be required, what does that look like? Making sure that, employees are washing hands and wearing gloves and all of these things. Perhaps we start out with appointment only. There's a number of things I think that we can do, but Is there 100% foolproof in this? No. I think that's why you see the Republican side of Congress wanting to introduce some level of protection, if you will, as it relates to liability, some liability protection for employers as they start to open up a little bit. Certainly there's that concern on that side of the aisle. So, is it 100% foolproof? No. Should we let common sense prevail? I believe so. But that's not to take away what, I heard a term the other day. There's the old, we've heard the term for years and years and years about drink responsibly. But I heard a term the other day and they called it socialize responsibly, which I think is an interesting term. And I think it's certainly one that, that if that we as individuals really have a responsibility to ourselves and to others, really to kind of evaluate our circumstances and, do our best to comply with what, the experts are telling us. But at the same time, how do we blend that with opening up our business, getting the economy rolling again, getting money into the pockets of our employees, and providing, going back to providing good service and good products.
It's something that we've been telling our clients consistently is in an age of ambiguity and a lack of complete full understanding and clarity, document.
Yeah.
Document everything, right?
Yeah. Well, I think, what was interesting is when the first FFCRA, the DOL, the IRS, HHS, they all got together and issued a rule that simply said, look, guys, this is uncharted territory for all of us, even the regulatory bodies. So for the first 30 days of this, it's going to be a non-compliance period. We're not going to we're not going to be heavy-handed. We're not looking to, drill down on people. Just use best efforts, use good common sense. And as we go down, the road, we'll figure out what this looks like. But I think that was one of the smarter things that the agencies did, because I think it allowed employers some, who were anxious about what do I do and how do I do this and should I, take certain measures and not certain measures and so on. But I think it allowed them the opportunity to really exercise some good judgment and some best efforts, and as we all attempt to navigate, this something we haven't seen in 100 years.
So meanwhile, other laws are still in place, right? So we've got the Affordable Care Act.
Yes.
And
Yes.
For many employers, they have to time track employees and make sure they're doing that appropriately for purposes of providing benefits and reporting back under the 1095s. And so how do you do that if you've furloughed employees? Do you have to count those hours? Do you not? What's the rule on that?
Yeah, no, and that's a great question. We do a lot of ACA work for groups around the country. It is our belief that probably somewhere in the fourth quarter, you're going to see the IRS come out with some guidance that relates to this year. There's been a lot of disruption, a lot of ALEs who came into the year as a designated ALE, and they just don't have the head count any longer. What does that look like? Folks who were furloughed, and to your point, yes, if you're furloughed, you're still employed. So the question is, and as we look at how we define hours of service, it's hours where an employee receives pay. They're either paid or they receive some level of compensation. But then what do we do with those weeks that, these furloughed employees didn't do anything? And unfortunately, it's going to be a week of 0 hours. And so I think there's got to be some relief down the road. For now, we've been given no guidance from the IRS that the rules have changed. We track as normal. Our payroll's our payroll records will reflect time away, wages that were not earned, not paid. But do I think that towards the end of this year, we're going to see something from the IRS that is going to help employers through this reporting cycle in 2020, going into 21? I think they almost have to. I think they almost have to do that. There's just too many organizations out there that are impacted by this.
So we had one question come in, and you may have just answered it, but I want to make sure we ask it again because we want to make sure that it is addressed. It says, I've heard to calculate the number of hours to pay for variable hour part-time employees, we should use the weekly average from the last 6 months. But I've also heard that to use the total hours from the previous 2 weeks. Which one of those is correct?
So it's actually both.
Okay.
Believe it or not, it's actually both. So if I have a variable schedule and variable employees, but they've been employed at least 6 months, then I'm going to use that 6 months average. I'm going to go back 6 months. If I've got somebody who's been, employed less than 6 months, I'm going to take a look at the average number of hours that employee and the employer agreed to at the time of hire. So I can use that particular number. If that was not in agreement, in other words, if when I hired you, I said, hey, I anticipate you working 25, 30 hours a week, so that's the number we're going to use. If that wasn't done, then I'll take an average by the day. In other words, how many days did you work? So I'm going to take an average by the day. As we know, under the paid sick leave, full-time employees are subject to 80 hours, right? They're entitled to 80 hours of paid leave. If for reasons 1, 2, and 3, it's at full pay. Reasons 4, 5, and 6, it's at part-time pay. If, however, I have a part-time employee and the number of available hours is calculated by averaging the number of hours, then I'm only going to do that over a 2-week period. So full-time employees, I'm going to look at, right, the 80 hours there. If I have a part-time employee, I'm going to look at the available hours. I'm going to get that average based over a 2-week period for my part-timers.
So let's talk about it kind of pertains to that, rehire provisions, right? Mm-hmm. So, I've let my employee go, let's just use as an example, and, things were going to open back up. I want to go rehire them. I didn't furlough them. I actually terminated their employment so they could go get, unemployment and potentially access to the Affordable Care Act, Obamacare plans. And now I'm bringing them back. How do rehire provisions play into that, specifically maybe even to variable hour employees that I need to time track?
Yeah. Well, if you have, if you're using the definition of variable hour because you're an ALE, as you know, under ACA rules, we have the 13-week rehire provision. So we're going to look at, are we rehiring this staff prior to the 13-week mark? Are they past the 13-week mark? As you know, prior to 13 weeks, we essentially pick back up where we left off. That 13 weeks is essentially a bridging. It's a bridging of whether you were previously enrolled and we're going to get you back enrolled. It's a bridging of the measurement period if you were not yet benefited, but you were currently in a measurement period. So depending on, if we're a large group, then we're going to look to our ACA rules and make a determination as to whether or not 13-week rule before 13 weeks, after 13 weeks. If you're a smaller group, really this is going to come down to your plan documents and carrier, where the carriers have been very gracious in allowing for rehires to be picked back up. Now, there's going to be some plan documents that need to be modified in order for that to happen. But certainly there's not that calculation that we'll have to do in a small group that we would normally have to do with an ALE in a large group.
What about employers that maybe utilize temporary visa employees?
Yeah.
What do they need to be?
Yeah. Unfortunately, the USCIS has not given us a lot of deference, if you will. By statute, if I have an employee, whether it's an H-1B, my E categories, my TNs, which are my NAFTA visas, my O's, there's a number of visas, work visas that are out there. There's a 60-day grace period when you lose status. So if an employer is looking to lay off or furlough, well, especially in a layoff where we're terminating, there's a number of things that have to happen. The employer has to notify USCIS with a notice. They also have to notify the Department of Labor with a notice because they're considered now out of status. That foreign national is now considered out of status. That foreign national now only has 60 days where they can continue to stay in the U.S. The other option is they can apply for a visa change. In other words, I could go from an H-1B, but I could try to apply for a visitor's visa. Maybe I want to go back to school, so I want to convert to a student visa. So there's a number of opportunities there. You could also look for another employer sponsor, someone who perhaps is willing to take you on, and they'll go through the process of getting you back on. But if none of that is occurring, once that visa holder has been laid off and is no longer employed, and that 60-day clock, now there is legislation that's trying to get that to 180 days. They're trying to move that through so that it would go from 60 days to 180. We don't have that just yet. So if it were to occur today, unfortunately, those folks are only going to have 60 days to figure out a plan of action.
As employers are opening up, right? Should they have a reentry document put together? Should they have a plan in place? And if so, what maybe should they put inside of that document?
Again, kind of going back to your earlier question about modifying our policies, I think this is where we create that policy about our standard, not only our standards of conduct, but also our maintenance, our sterilization, our cleanliness. Perhaps dress codes will need to be amended. And then making sure that all of this is communicated to our employees prior to them coming on. There is some, I don't want to say argument, but there is certainly some disagreement as to whether the mask itself is considered PPE, which, as you know, under OSHA, generally PPE is an item that must be provided by the employer, versus being strictly, if we're going to allow for a cloth face covering. The argument right now is, and this is, as you know, right, when we get into the law, we argue the nuances. Is a face covering a mask? And does a face, so if I allow for face coverings, am I necessarily subject to OSHA's rule on PPE? But if I'm in an environment that requires a mask, and it requires, for example, an N95 mask, well, then I'm probably getting into the PPP realm. So again, and plus it's going to depend on your jurisdiction. Here, face coverings are optional. Face coverings can also be cloth. Face coverings can be masked, but you see a lot of folks around town here in the last week or so that have kind of gotten creative, if you will, with their kind of bandit mask and things like that. We're going to start getting into perhaps some religious issues, because, as you know, there's been a number of jurisdictions that have talked about face coverings and IDs going into airports with your face covered. And so, what if a face covering? What if I have a medical condition? So we get into ADA issues. So it's going to be interesting as we start to see where the nuances fall with these face coverings. Clearly, as a private employer, we've seen plenty of examples: Costco, Walmart, Menards. There's a number of big box type stores that are now requiring this. Kroger's, which is perhaps the largest grocer in the United States, has been discussing the idea. So as an employer, I think there's things that we can do there, but it's going to be, policies are going to need to change. I think there's going to be documentation, as you pointed out earlier, of protocols and policies, and then what do we do with other aspects, again, as it relates to whether it's ADA, whether it's religious accommodations, whether it's other particular issues.
Certainly, and not a lot to.
It's not boring.
Right? I know, right? And the acronyms will continue to fly.
They will. They will.
Listen, if you've just been joining us, our guest today has been Mark Rambo, compliance specialist, co-founder of HR Workplace Services, and the director of compliance for us at GDP Advisors. Mark, man, I know you're a busy guy. It took me 2 weeks to get you on the calendar to do this, but you're gracious enough to do it. I probably,
for sure.
well, I know I email you probably a dozen or 24 times a day, so I appreciate that. Thanks for your wisdom. I think that if you're a guest and you're not working with somebody like Mark, you're probably going, man, I surely should be. So thank you, my friend, for being here. For all of those that, thank you. For all those that made this happen, thank you to Andrew Clark, our producer behind the scenes, working hard, to our entire team at GDP Advisors. Until we meet again on the Doctor, we'll see you now. Thanks. Have a good one.